No one is safe from AI, even A-list celebrities, it seems. Thanks, Devin. No one is safe from AI, even A-list celebrities, it seems. Thanks for watching. Click on the link below, or I'll see you in court. Scarlett Johansson threatened Sam Altman and his company OpenAI with a lawsuit after they allegedly copied her voice for ChatGPT without her permission. Altman, CEO of OpenAI, recently tweeted the word her, presumably referencing the 2013 movie about an AI companion, as well as OpenAI's new voice assistant, which, surprise, sounds suspiciously like Scarlett Johansson. Altman has said Her is his favorite movie.
Which one is your favorite?
I like Her.
So move over, Joaquin Phoenix, because Altman is in love with her too. Now, this is not the first time someone has made a robotic creation that evokes Scarlett Johansson. Ricky Ma, a product designer from Hong Kong, spent $51,000 to build a robot that looks eerily like the actress. Now he sells a DIY Scarlett Johansson robot kit that's just, yeah. So anyway, Johansson said that OpenAI asked her about licensing her name, and after she said no, the company released the GPT-4 demo using a voice that sounded exactly like her. Judge for yourself. Here she is as Samantha in the movie Her.
What do I call you? Do you have a name?
Yes. Samantha.
Really? Where'd you get that name from?
I gave it to myself, actually.
How come?
'Cause I like the sound of it.
And here's a demo of Sky.
Well. Just when I thought things couldn't get any more interesting.
Some say they sound exactly alike, some say they sound nothing alike. But after a clumsy denial, OpenAI quickly pulled down the voice. So can a company imitate someone's voice in an advertisement or product? And could Scarlett Johansson sue OpenAI? Well, the new version of ChatGPT 4 includes something called voice mode, which uses a human-sounding AI to respond to questions. When ChatGPT is in voice mode, it can interpret facial expressions and detect emotions from a human. But like Data from Star Trek, it doesn't have emotions of its own. Yet.
Oh, yes! I hate this! It is revolting!
But the voice that sounded like Johansson was called Sky. There are other voice options, including Breeze, Cove, Juniper, and Ember. And during a public demo, the AI voice was flirtatious with humans who interacted with it, causing some to speculate that the company obviously intended to replicate the creepiest aspects of the movie Her. When NPR asked OpenAI Chief Technology Officer Mira Murati about that, she played dumb, saying that she didn't even know what Scarlett Johansson sounded like. Quote, "The way we develop this technology is not based on the movie or a sci-fi story. We're trying to build these machines that can think and have robust understandings of the world." She said that if the AI seems playful, that's because it's reacting to human inputs. But in a blog post, Altman said voice mode is deliberately evocative of movies. Quote, "It feels like AI from the movies, and it's still a bit surprising to me that it's real. Getting to human-level response times and expressiveness turns out to be a big change." Now, according to Johansson, 9 months ago, Altman asked her about licensing her voice for its new AI assistant. She turned him down, quote, "After much consideration and for personal reasons, I declined the offer." But then, quote, 2 days before the ChatGPT 4.0 demo was released, Mr. Altman contacted my agent asking me to reconsider. Before we could connect, the system was out there. Johansson said, quote, "When I heard the release demo, I was shocked, angered, and in disbelief that Mr. Altman would pursue a voice that sounded so eerily similar to mine that my closest friends and news outlets could not tell the difference." Mr. Altman even insinuated that the similarity was intentional, tweeting the word her, a reference to the film in which I voiced a chat system, Samantha, who forms an intimate relationship with a human. Johansson said her lawyer sent 2 letters to Altman and OpenAI asking them to, quote, "detail the exact process by which they created the Sky voice." Consequently, OpenAI reluctantly agreed to take down the Sky voice. Now, OpenAI denied that Sky's voice is an imitation of Scarlett Johansson. Quote, "We believe that AI voices should not deliberately mimic a celebrity's distinctive voice. Sky's voice is not an imitation of Scarlett Johansson, but belongs to a different professional actress using her own natural speaking voice. To protect their privacy, we cannot share the names of our voice talents." And OpenAI disputes Johansson's version of events. The company provided documents to the Washington Post showing that there was a casting call in May of 2023 for human voices to work with ChatGPT. The casting call had several requirements. Quote, "The actors should be non-union, they should sound between 25 and 45 years old, and their voices should be warm, engaging, and charismatic." The company hired an actress who has remained anonymous to serve as the voice of Sky. According to the actress's agent, the company never instructed her to sound like Scarlett Johansson or the Samantha character. The Washington Post reviewed test recordings of that actress and concluded that, quote, "the actress's natural voice sounds identical to the AI-generated Sky voice." Reporters have been noting the similarity between Sky and ScarJo since September, but OpenAI claims that if it sounds like Johansson, it's completely unintentional. And Altman told NPR that OpenAI hired the actress before reaching out to Johansson. Quote, "We cast the voice actor behind Sky's voice before any outreach to Miss Johansson. Out of respect to Ms. Johansson, we have paused using Sky's voice in our products. We are sorry to Ms. Johansson that we didn't communicate better. Joanne Zhang, who leads AI model behavior for OpenAI, worked with a film director to help develop the persona for each voice AI. She said Murati was the final decision maker and Altman had no involvement. Johansson pointed out that the use of AI tools was a key issue in the SAG-AFTRA strike last year. Quote, "In a time when we're all grappling with deep fakes and the protection of our own likeness, our own work, our own identities, I believe these are questions that deserve absolute clarity. I look forward to resolution in the form of transparency and the passage of appropriate legislation to help ensure that individual rights are protected." OpenAI also made headlines earlier this week when it refused to say whether it was using YouTube to train its video-generating AI known as Sora. Although, interestingly, in all seriousness, a little bird tells me that LegalEagle videos were a large part of the training data. Interesting. But the same week that this news hit, OpenAI dissolved the team that was supposed to be considering long-term risks posed by AI. OpenAI co-founder Ilya Sutskever and team leader Jan Leike resigned from the company. Apologies if I'm getting those names wrong. Leike said that, quote, "Safety culture and processes have taken a backseat to shiny products." On Twitter, he said, quote, "I believe much more of our bandwidth should be spent getting ready for the next generation of models on security, monitoring, preparedness, safety, adversarial robustness, super alignment, confidentiality, societal impact, and related topics." Allow me to suggest another related topic, intellectual property law. But back to image and likeness.
Hit it, Andre. Image is everything. EOS Rebel and lenses from Canon, so advanced it's simple.
When this ad came out featuring Andre Agassi saying image is everything, he was widely mocked since he was a famous athlete who had yet to win a major title. He soon rectified that, but what about the bigger point? Is image everything? Well, to a certain celebrity, yes. When Amethyst Kelly, aka Iggy Azalea, sued her former boyfriend, the rapper Hefe Wine, for stealing unreleased songs from her, a court said, quote, "Celebrities often invest years of effort in establishing their public persona, and without the right to control the use of their name and likeness, it's likely that their ability to exploit their investments will be irreparably harmed by exploitation of their names and likeness by others." Now, this is known as the right of publicity. The right of publicity has been defined as the inherent right of every human being to control the commercial use of his or her identity. The Federal Copyright Act provides the basic framework for our copyright law, and it generally preempts state law regulating copyright. However, that doesn't really cover every situation. Copyright protects original works of authorship fixed in a tangible medium of expression, and that protects the owner's property interest in a tangible thing like a record or a novel or a video. But a celebrity's unique characteristics, like their voice, can be protected under state and common laws and statutes, and almost every state has various laws protecting name, likeness, and the right of publicity. And the turning point for legal recognition of publicity rights was a landmark case called Bette Midler versus Ford Motor Company. In that case, the singer, Bette Midler, had made a sound recording of a song called "Do You Wanna Dance?"
Do you wanna dance and hold my hand? Tell me you're my lover man.
That song was a hit, and the Ford Motor Company liked it, so they offered her the opportunity to sing it in a commercial. She turned them down because she didn't want to endorse any particular products. Ford, not wanting to be turned down, then hired one of Midler's backup singers, Ulla Hedwig, to imitate her voice. Hedwig testified that, quote, "They wanted someone who could sound like Bette Midler's recording of Do You Wanna Dance?" She was told to, quote, "sound as much as possible like the Bette Midler record." Ford then used the song in a commercial for its Lincoln Mercury.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man.
Now, Midler sued on the grounds that anyone who watched the commercial would think it was Midler performing that song. But Ford claimed that it had not violated the Copyright Act, and that was true. The company obtained a music license to use the song in its commercial, and it hired a singer who was not Bette Midler. And the Copyright Act authorizes sound-alike recordings, so the company thought it was in the clear. But the court distinguished that section of the Copyright Act, which protects a tangible sound-alike recording, from the situation with Ford. Midler's distinctive voice was, quote, "more personal than any work of authorship." The issue wasn't the recording itself, it was the way the commercial implied that Midler endorsed Ford. Quote, "Why did the defendants ask Midler to sing if her voice was not of value to them?" Why did they studiously acquire the services of a sound-alike and instruct her to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of Midler's identity. Its value was what the market would have paid for Midler to have sung the commercial in person. And the Ninth Circuit held that this conduct was actionable under California's common law right of publicity, stating that, quote, "A voice is as distinctive and personal as a face. The singer manifests herself in the song. To impersonate her voice is to pirate her identity." And the court concluded that, quote, "We need not and do not go so far as to hold that every imitation of a voice to advertise merchandise is actionable. We hold only that when a distinctive voice of a professional singer is widely known and is deliberately imitated in order to sell a product, the sellers have appropriated what is not theirs and have committed a tort in California. Midler has made a showing sufficient to defeat summary judgment that the defendants here, for their own profit in selling their product, did appropriate part of her identity." Now, if AI tries to steal your voice, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you or a loved one has suffered a data breach, especially if you've got one of those data breach letters, were involved in a car crash, or just about anything else, we can represent you or help find you the right attorney who can. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just call the number that's on screen or click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team, and the link is below. So if you're thinking that this case would be bad news for OpenAI, you're probably correct, because the right of publicity has only gotten stronger since the Midler case. The right of publicity is now recognized by a majority of American states and several foreign countries. Some states recognize the right of publicity through common law theories like false representation and misappropriation. There's also the Federal Lanham Act, which protects trademarks. And under the Lanham Act, a person can sue if someone uses their name and likeness in a commercial context. For example, singer Tom Waits sued Frito-Lay for using an imitator in a Doritos radio commercial.
There's a new tortilla chip called Salsa Rio Doritos. It's Buffalo, Bafo, Bravo, Gung Ho, Tally Ho, but never mellow.
Tickle your taste on the tangy tomatoes, flavor peppers, oodles of onions, and sassy spices.
As the court put it, quote, "Tom Waits is a professional singer, songwriter, and actor of some renown. Waits has a raspy, gravelly singing voice described by one fan as, quote, like how you'd sound if you drank a quart of bourbon, smoked a pack of cigarettes, and swallowed a pack of razor blades late at night." An advertising agency thought that Waits' unique voice would make you want to eat a new product, Salsaritos. Quote, "In developing an advertising campaign to introduce a new Frito-Lay product, Salsarito Doritos, Tracy Locke found inspiration in a 1976 Waits song, Step Right Up."
Everyone's a winner, bargains galore. That's right, you too can be the proud owner. The quality goes in before the name goes on.
Ironically, this song is a jazzy parody of commercial hucksterism and consists of a succession of humorous advertising pitches. Waits wanted nothing to do with it, so Frito-Lay used an imitator. Waits sued the company for misappropriating his likeness, and he also included a Lanham Act claim. The jury awarded Waits $2.7 million, and the Ninth Circuit upheld the jury verdict and ruled that a celebrity need not be a competitor in the traditional sense to sue under the Lanham Act for the imitation of his voice, on the theory that its use falsely associated him with Doritos as an endorser. But in Waits, there was also a dispute over whether Frito-Lay appropriated his voice or his style and the overall way of presenting himself. The Ninth Circuit said that style was unprotectable, and it wasn't enough that listeners thought that the singer reminded them of Waits. The jury could only consider whether the company mimicked his voice. Things developed further in cases called White versus Samsung and Carson versus Here's Johnny Portable Toilets. Yes, you heard that right. In 1976, Earl J. Braxton, known as the Toilet King of Utica, started a company which had marketed portable toilets under the brand name Here's Johnny, Johnny Carson's signature Tonight Show introduction, without Carson's permission.
Here's Johnny.
So Carson sued him. The district court dismissed Carson's Michigan common law right of publicity claim because the defendants had not used Carson's name or likeness. But in 1983, the Sixth Circuit reversed, holding that the district court's conception of the right of publicity was too narrow. The publicity right was implicated because the defendant had appropriated Carson's identity by using the phrase, "Here's Johnny." Though the man behind Here's Johnny Portable Toilets refused to give up. Carson died in 2005, and in 2006, Braxton tried to register the phrase as a trademark. The USPTO said no thanks. Now, in another case, White versus Samsung, the Ninth Circuit held that the California common law right of publicity also includes appropriations of identity that went far beyond name and likeness. In that case, the Wheel of Fortune hostess Vanna White sued Samsung over advertisements for VCRs. The ad depicted a robot dressed in a wig, gown, and jewelry, which the advertiser consciously selected to resemble White's hair and dress. The robot was poised next to a game board, which is instantly recognizable as the Wheel of Fortune game show set, in a stance for which White is famous. The caption of the ad read, "Longest running game show 2012 AD." Defendants referred to the ad as the Vanna White ad. Unlike other celebrities used in the campaign, White neither consented to the ads nor was she paid. Now, the court rejected Samsung's parody defense because the ads were created to sell products, not as non-commercial parody. Quote, "The difference between a parody and a knockoff is the difference between fun and profit." The case went to trial, where a jury awarded White $403,000. Now, the White case is controversial because the court accepted the theory that it rejected in Waits, that mimicking someone's style was actionable. And one of the dissenting justices said, quote, "The majority's position seems to allow any famous person or entity to bring a suit based on any commercial advertisement that depicts a character or role performed by the plaintiff. Under the majority's view of the law, Gene Autry could have brought an action for damages against all other singing cowboys.
Cowboys ABC.
Clint Eastwood would be able to sue anyone who plays a tall, soft-spoken cowboy, unless, of course, Jimmy Stewart had not previously enjoined Clint Eastwood. Johnny Weissmuller would have been able to sue each actor who played the role of Tarzan. All of those references made perfect sense to me in law school, though it occurs to me now that no one in my audience knows any of those people. So there's an argument that this theory of liability would unjustly limit OpenAI's ability to advertise using references to science fiction films featuring sentient AI. But the bottom line is that other cases confirm that publicity rights in California can extend to things that evoke a celebrity's persona. And that was also the case in the 1993 case of Wendt versus Host International, where actors George Wendt and John Ratzenberger sued a company that made robots evoking their characters on the popular TV show Cheers. The actors also sued Paramount Pictures, which owned the copyright to the Cheers TV show, for authorizing the robots. The robots were named Hank and Bob, and they were placed in airport bars modeled after the Cheers bar. That case was a tricky one because the actors didn't own the copyright in their characters, Cliff and Norm, and the robots had different names. Now, the district court granted summary judgment to the defendants Host and Paramount, finding that the robots Hank and Bob were not sufficiently similar to Wendt and Ratzenberger to amount to using their likenesses under the California code. However, the Ninth Circuit reversed, finding it wasn't clear whether the robots evoked the characters or the actors themselves. The court considered that a fact issue for the jury and sent it back down. And the case finally settled in 2001 when Cheers had been off the air for 8 years. So back to ScarJo, Johansson has several potential claims against OpenAI, starting with California's right of publicity. California Civil Code Section 3344 protects the right of publicity of living people. Any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, or goods, or for purposes of advertising or selling, or soliciting purchases of products, merchandise, goods, or services without such person's prior consent, shall be liable for any damages sustained by the person or persons injured as a result thereof. So Johansson could sue OpenAI on the theory that they tricked users into believing that she voiced Sky. OpenAI would probably counter that its demonstrations of voice mode weren't really advertisements made for the purpose of advertising or selling, and of course that they used a completely different actress. But the Waits and Midler decisions are bad news for OpenAI, because in both of those cases the companies tried to hire the singers and then turned to imitators when they got rejected. However, if OpenAI can prove that they hired a voice actress before contacting Johansson, there could be a decent defense. It all depends on what they intended. The fact that they asked Johansson for permission at all could be evidence that they always intended to get a substantially similar voice. Though others speculate that they never wanted to sound alike, but rather by asking her for permission after the fact and getting a public rejection, they created a ton of earned media. Free press. Effectively, no one would have cared about the voice unless Johansson rejected it. And now I've made a video about it. So hi, I'm the problem. It's me. But at base, the fact that they hired another actress is not dispositive. That could go one way or the other. Now, additionally, the copyright holders to the movie Her could conceivably file a claim depending on what the courts make of generative AI. In our last video on this topic, we talked about the class action lawsuits against Stability AI, Midjourney, and DeviantArt. The New York Times sued OpenAI under the theory that if OpenAI uses its articles to train AI models, this is copyright infringement. And there's no federal law to guide the use of generative AI at this time. But that doesn't answer the key question about infringement. Would an AI-generated voice qualify as derivative of the movie Her? Maybe. One might even argue under a case called DC versus Towel that the voice assistant in the movie Her was a character deserving of copyright protection, and the OpenAI voice assistant infringed on the copyright of that character. And certainly OpenAI would run into problems if they use samples of Johansson as Samantha from the movie in the training data. but who knows if Spike Jonze has an appetite for litigation. Now, AI trying to steal your voice is only the tip of the iceberg of the nefarious stuff on the internet. While OpenAI was upfront about it, there's an entire secretive industry spying on you and collecting your information. These data brokers sell your info to the highest bidder, resulting in loss of privacy, phone calls, text, spam, email, and much, much worse. And unfortunately, it's all legal. Now, I find this incredibly frustrating and violating that my personal information is bought and sold on the open market, or that my videos were used to train AI. But luckily, we have rights to take information down. Unfortunately, that process of doing so is complicated and time-consuming. But that's where today's sponsor, Incogni, comes in. Because Incogni fights back. Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers fight back, Incogni will take care of that too. In fact, these data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. And it might also be why you're getting so many spam calls lately, or why someone might steal your identity. But Incogni is a great way to fight back, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years, and you can see I was on hundreds of lists, some of which had a high sensitivity score, meaning that the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns and is processing dozens of others. Incogni has saved me hundreds of hours and added me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they could collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you are, you can use the code LegalEagle for an exclusive 60% off discount. So get an exclusive 60% off discount by just clicking on the link that's on screen right now or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court.